Are we talking about some illegal swap activity? Hmm, I see. Okay. Well, let's keep going here. A 1983 case, Emergency Energy Reserves Group Inc. versus Kansas Power and Light Company, summarized the modified rules. First, the court determines whether a state law operates as a substantial impairment of a contract. The criteria for making that determination are unclear, but a regulation that eliminates, quote, unforeseen windfall profits, end quote, will not automatically be invalidated. Apparently, laws that limit parties to realizing their original contract expectations will be upheld even if one of the parties, in accordance with the agreement, is entitled to greater benefits. Moreover, if the signatories operate within a heavily regulated industry, they should anticipate that courts will be especially reluctant to override legislative alterations of a commercial contract. Second, assuming that substantial impairment were established, the state could nonetheless defend its regulation by showing that it had a, quote, significant and legitimate public purpose, end quote, such as targeting, quote, a broad and general social or economic problem, end quote. Notably, the problem no longer had to qualify as an emergency. Indeed, in Kansas Power, the statute upheld by the court simply capped price increases under a natural gas supply contract. What had been touted as a dire national crisis in Bladesdell became a mere economic hardship in Kansas Power. Third, as in Bladeswell, the court will overturn state imposed adjustments to the rights and responsibilities of contracting parties only if those adjustments are, quote, unreasonable, end quote, when related to the purpose of the legislation. And because the judiciary traditionally rubber stamps legislative judgments when reviewing commercial and economic regulations, the question whether a particular measure is reasonable in light of its presumed goals will rarely, if ever, be scrutinized. End quote. This whole contract thing started with a term, or rather a statement, that the Constitution is itself a contract with the people. From what has been presented tonight, could I substantiate, based upon what was made available here, that claim? I believe I can. Insofar as it is a existing compact, and the determination of a compact as being a foundation for discussion of contract, and then insofar as the Constitution is the existing contract, which is the basis upon determining compliance with it, based upon execution of other agreements and implementation of the tenets of the contract that is the Constitution, I believe yes, it is. Not only that, one of the things that this has been saying about the emergency, insofar as the majority opinion quoted, emergency may furnish the occasion for exercise of power. It may not call into life a power which has never lived. Nevertheless, emergency may afford the reason for the exertion of a living power already enjoyed. If you demonstrate that you have cognizance, competence, capability to engage in exercise of a particular power or capability associated with the exertion of an existing power, then an emergency situation cannot be invoked in order to attempt to impair your capacity to deliver on that contract or to engage in performance of that contract. Not only that, as these other additions demonstrate, as the 1983 case demonstrates, it also means that you cannot at another time engage in non emergency imposition of or by the state in order to preclude the exercise or exertion of a pre existing or already existing power, including one that has already been committed to through a contract relationship or engagement. So it's both a matter of need to disclose beforehand in order to assure the terms of the contract from the onset or engaged constitutionally in order to make it valid and binding, but also to not prevent or preclude the capacity for the successful accomplishment of a contract that was willfully and knowingly engaged by imposition later of either an alleged emergency action that does not comport with the Constitution or an interference by the state in an effort to attempt to unduly influence or otherwise impair the capacity to complete or follow through in the contract. If people in public office are attempting to manipulate certain private citizens in order to make available the illegal expropriation of their private property, and that impairs their capacity to deliver on a contract relationship they've already engaged, including a financial one, so as to create the conditions for permitting a lien to be placed upon that person in efforts to expropriate their personal private property and make it available to someone else, that is not constitutionally valid. It does not hold. Period. You can't do it. You couldn't do it then, and you can't do it now. So if you're attempting to try to cover up for the fact that you've engaged in unconstitutional legislation, well, I mean, we already know that you can do that for 70 years and it still holds. Even if you get away with it. Well, we did it. Yeah, we'll do it another year. We'll do it another year. Precedent's already been set. Even if you try to get away with it for 70 years, it's still not constitutional. It can still be undone.